Hi, welcome everyone to the April edition of the Holland Knight International Private Client Webinar Series. Today's topic is navigating the U.S. immigration system in a time of uncertainty. I am joined today by my colleagues Leon Fresco and Jason Klitenic, and we will be introducing ourselves a bit. My name is Lauren Klein. I'm an attorney in our Miami office in our private wealth group focusing on international trust and estates and tax planning. I'm going to let Leon and Jason introduce themselves briefly, and then we will get started with our presentation. Thank you for being here.
Good afternoon or good morning, depending where you are. My name is Leon Fresco. I've been at Holland Knight now for the last 4 years as a partner doing immigration law, representing people and companies all over the world, having people both come in and leave the United States, depending on what their interests are. And before then, I worked for the Department of Justice, where I represented the government in every piece of litigation that was filed against the government, whether it be on immigration, whether it be against the State Department or ICE or CBP or U.S. Citizenship and Immigration Services. I was the person in charge of that department that represented the government on those lawsuits. And before then, I was at the U.S. Senate, where I was a staffer who was the staff director of the Senate Immigration Subcommittee. And so with that experience, I'm able to represent clients with pretty much any immigration issue that they have. And so I'm happy to be at the firm and happy to be doing this webinar. Now to Jason.
Great, thank you. I'm Jason Klitenic. I'm a partner here in our Washington, D.C. office. I lead our firm's national security practice. Like a lot of folks in our office, I've been in and out of government throughout my career. Most recently, I was the general counsel to the Director of National Intelligence, where I work closely with the 17 agencies that make up the intelligence community. Prior to that, I was a senior official of both the U.S. Department of Homeland Security and U.S. Department of Justice. Here at the firm, we handle a variety of national security matters, including representing high net worth individuals who are either applying for a visa and finding that they are having trouble getting their application approved, or individuals who have visas and find that their visas are being revoked or otherwise canceled. And so we help clients work through those issues, working closely with the U.S. government. Thank you.
Okay, and so with that, each of us are going to talk for a little while, and then we will turn to your questions. So I'm going to talk about 4 topics today that are addressing maybe some of your concerns about the uncertain immigration system at the moment. There's COVID travel bans that are happening right now through a large segment of the world. There's embassy closures and reduced capacity due to COVID. There's USCIS delays, and there's upcoming changing laws and procedures. So I'm going to talk to you about all 4 of those items. So first, let's talk about COVID travel bans. So if you are sitting in any country in the European Union or the United Kingdom, or you're sitting in Brazil or China or South Africa, what you will find are 2 different problems that you have entering the United States. The first is, if you don't have a visa, then you will not be given a visa appointment at any of those countries, because the countries are not allowed, or the United States is not allowed to give visas in those countries, because people from those countries who are inside the country are banned from entering the United States if they've been in that country in the last 14 days. So it's a very interesting kind of circular position where they won't give you a visa if you are in the country, and then even if you say, well, I'm going to now fly to another non-banned country like Mexico or Jamaica or Bermuda or something, you can't get a visa to camp out in some other country for 14 days because the embassy is not providing a visa for anyone who is on the banned list. If you have a visa, you still need to either wait in one of the non-banned countries for 14 days before trying to enter, and they will want proof that you did that. So you'll have to show the stamp of the country you were waiting in, and then the airline manifest and all of that to show that you've been waiting those 14 days. And they'll know because you will be presenting a passport from one of the banned countries. So that's what makes it complicated is if you present one of those passports from one of the banned countries, you'll either have to have this evidence that you were out the last 14 days, or you'll have to have what's called a national interest exception. Now, that national interest exception is only available to banned individuals from the EU and the UK. It's not available to banned individuals from Brazil, China, and South Africa. So if you're from Brazil, China, and South Africa, your only hope to get into the United States is to go to a third country and wait. And a lot of third countries right now are also not letting in people who are traveling from Brazil, especially. That's a big problem now, is Brazilians have been locked out of Panama, which was a big place where people were waiting. And also now even many flights into Mexico from Brazil, we're starting to see people get turned back to Brazil on those flights into Mexico, because even though Mexico hasn't banned Brazilians, they're certainly concerned about the situation, and they're kind of having this haphazard application of their immigration laws in Mexico. And so if you're in the EU, you can do a procedure which we help a lot of clients with, which is to ask for a waiver of this ban so that you can fly directly to the United States. And so what we do is we put a package together and we explain why you are in one of these sectors, if you are traveling for one of these sectors, which are called critical infrastructure sectors. And even though the critical infrastructure sector is very narrow, there are a lot of occupations and industries within the critical infrastructure field that hopefully we can try to find a way to get your travel into one of these critical infrastructure exceptions. But again, you have to be going to do something. If you just say you're going to be observing operations or holding meetings, that's going to be something they're not going to let you do, because they're going to say you can do what we're doing right now and do this on the internet. And so you don't need to be there for that. So you have to explain, the key is why your actual presence is needed, your physical presence is needed in the United States. And we do that quite a lot. We're getting, a lot of success on that, but that's a very important thing. And then if you're from the EU, you can get an exception to enter. You also don't need that exception if you're from the EU to come on a student visa or a government visa or a crew member visa, but you do need it for all of the other visa categories. And if you're from Brazil, again, or China or South Africa or Iran, then in those situations, there is no such exception for any of the visas. And so what you'll have to do is either, if you do have a visa, you'll have to wait 14 days outside of the United States. But if you do have a visa, if you don't have a visa, then they won't grant it. You have to go to a whole other country and ask for a visa appointment to get your visa adjudicated. And a lot of people were saying this issue of, well, they own a company in the United States, and because I own the company, I'm creating jobs. And so now those cases are not as straightforward, and they go to the actual State Department in Washington for those to be approved. And so those are much harder to do. Now, around the world, regardless of what embassy you're talking about, there's both closures of embassies, and we see that off and on all around the world. China's an example of a place where there's a lot of traffic, but there's no open embassy where you can get appointments right now. And there's also reduced capacity all over the world, because what happened was during COVID, a lot of the State Department adjudicators actually returned to the United States. And in order for them to return back to their countries, they need, it's called the State Department appropriation, which is funding for them to return back. And that's being done on a sort of ad hoc basis, where a lot of these consulates right now are running at about 40% capacity. And so what we're seeing is they're prioritizing cases that are urgent cases, like student visa cases, people with urgent travel needs, foreign diplomats, people assisting with the pandemic, and critical infrastructure. So the key is the more urgent one can say that your travel is, and the more urgent the deadline is. That's the key, is the deadline factor of this, is the more likely you're going to be able to get an appointment to get a visa. Because right now, regular appointments, meaning the process by which one goes to the U.S. Embassy website and books an appointment, those are impossible to get in the visitor visa context. And even in the student visa context, you get an appointment for like 2022, And then what you need to do is show the deadline so they can speed up your appointment on a faster note. Okay, I'm just looking at my time. I have 4 more minutes here. On the USCIS front, because of COVID, there's delays all through the system. If you're asking for permission to work in the United States or permission to get a green card or some other application that allows you to either work or stay in the United States that isn't just to visit, you have to go through USCIS. And right now we're seeing it's taking them even 6 weeks to literally open the envelope of a case, cash the check, and send you back a receipt saying you have an open case, much less how long it's taking to actually adjudicate applications. We're seeing huge delays in cases of married individuals where what happens is the person who's the worker or the business owner, they can get their application approved with something called premium processing, which is fast, but the spouse is stuck in a 6-month to 8-month backlog because there was a decision made about a year ago in the prior administration to separate those out and not adjudicate those together. And until that's changed, this is creating a large backlog of applications where literally one spouse will have perfect immigration status and the other spouse will have this pending quasi-immigration status where the status they came in has already expired and they're waiting for this other application to be granted. So if you're in a marriage situation like that, it's important to be represented by legal counsel because there's a lot of pitfalls there with regard to what to do, when you can travel, all of that kind of stuff. So that's very important to consider. And then finally, all of the sort of bandwidth is unfortunately not really focused on that right now and is focused on this issue of what to do about the border, what to do about people here who are undocumented. And so that's where a lot of this is going on right now. And so we're gonna be seeing more and more policy guidance and time spent on that in terms of who can the Immigration and Customs Enforcement remove, who is going to be allowed into the United States through the southern border and for what purposes, and how, whether there will be an expansion of the program of DACA for minors here, so that people who've come post 2007, which was the last deadline, the DACA was done in 2012, but you had to be here for 5 years in order to get DACA. So you had to have come before 2007. Will DACA be expanded, and then will it also be allowed by the courts to prevail, or will it be taken away by the courts, and then will Congress need to get involved? And if Congress does need to get involved, will the Congress actually do something? Will you see temporary protected status for more countries? We've already seen it for Venezuela now. So Venezuelans who were here at the beginning of the year can stay until basically for 18 months, but basically it's expected to remain for the entirety of the Biden administration. So will people that are not just Venezuelans, new categories of people are talking about Haitians, Nicaraguans potentially, and other Central American countries potentially getting temporary protected status. Will that happen? And if so, can new groups of individuals be allowed to stay? And then also the potential new implementation of parole programs. And this is big for people who did not come in the United States legally, meaning they crossed the border, they didn't just overstay, but then they married a U.S. citizen. Those people, there's this misconception if you marry a U.S. citizen, you're fine. That's not true if you cross the border illegally. But there are rumblings that a parole program will be created that will allow those individuals who crossed illegally to parole in the United States so that they can then apply for a green card using the legal system. So we will wait and see on those developments, but you see it's a constantly evolving subject. And so and we've already talked about the congressional stuff. And so any week that you're having this presentation, you're going to have different things to talk about. And so that's why it's important to constantly have guidance from a lawyer, because literally the same application they told you was fine last week might not be fine this week for a number of different reasons. COVID, changes in policies, changes in the law. And so it's important to look at that. So with that, I'm going to now transition to my esteemed colleague, Jason Klitenic, who will now do his part of the presentation.
Great, thank you, Leon. I'm happy to report my presentation fits on a single slide. But yeah, as I mentioned earlier, I've been in and out of government. A lot of the time I've spent here at Holland Knight has actually been representing high net worth individuals, foreign nationals who have had a variety of issues arise, particularly in the national security context when it comes to their visas. Typically, these visas are B1, B2 visitor visas. They either, they've had them for years, they've always come to the United States. Many of them actually grew up in the United States. And then something happens, and the something that happens is either they apply first, maybe in the first instance, to get their visa, and it either gets denied or it's just taking a really long time, and they get a notice saying it's been subject to 221G, which is an INA statute, but it means administrative processing, and that is often an indication that there could be a concern on the government's behalf. It could also be not only either applying in the first instance for a visa, but also renewing a visa. But also instances I've had clients who are rocking along and they're back in their home country or city in any continent in the world, and they get asked to come down to their local U.S. consulate, and they come down and they're asked to bring their passport, and they do, and they present their passport, and their visa gets canceled on the spot. They're not given an explanation as to how that may have happened. So then they reach out to us. Part of what we do is help work with them, work with the government, and try and identify what the problem may be, and to see if it's something that can be addressed. Is the problem solvable? Is it a misunderstanding? Sometimes do they have the wrong name, with transliteration, and sometimes the names can get mixed up, or other indicators. I think it's important, what we always tell clients, what I always tell clients is I'm never going to be the one that goes into the meeting with the government and bangs on the table and says how outrageous this is that this individual, my client, has had his visa either canceled or denied, because that, I don't believe that would be a credible argument with the government, because a lot of times what we tell our clients is, the government may know more about the client than the client knows about himself or herself. And so this really is I believe it to be a trust building exercise where gain the trust of the client, make sure the client's comfortable with the dynamic, which is providing information to the government, being transparent, and then also as it relates to the government, making sure that you can be a trusted confidant in trying to address the issues. I will say that I put a bullet point in here. It says visas are viewed to be a privilege, not right. That just kind of goes to what I was saying earlier. The government has a fair amount of discretion when it comes to granting visas and other immigration benefits, and so the dynamic is often the government holds the cards, and it's just, I always think, very important to be mindful of that. The role of legal counsel, legal representation, I think our clients would say we do and have provided value in the past, and that can be anything from helping them with the visa application itself, filling out the form, understanding what the questions, the information, what the questions seeks, the level of information, and then again, always reiterating the importance of being transparent with the government. And if there are issues in the client's background that give the client cause for concern, then we, as counsel, can kind of walk through those issues, and typically we can address them in a way that's obviously accurate, correct, honest, transparent, but also, fairly represents the client's standing. And then there are other instances where when you work through the issues with the client may decide, I can travel to any number of different countries in the world, but the United States, I do have concerns about my background, and I'm just not going to pursue a visa at that time. And that also obviously is fine. One thing I wanted to mention, again, everything I'm sharing with you is based on my experience in the private sector as a counsel, as a private attorney to individuals. And again, our clients have come from all over the world. It's not just the types of countries or regions that you think would garner particular interest from the United States, but it's been everyone in every place, Scandinavians, Brits, Western Europeans, as well as other countries that, again, you would expect to maybe garner interest. A lot of what I've noticed over time is these clients that have a lot of wealth. With that, it attracts attention. It attracts attention not just from the government, but also from people that I would characterize as people who have good intentions and people who have bad intentions. And so we've seen clients stumble into unwittingly engaging in transactions or other business relationships with individuals who our clients at the time did not fully appreciate, what those other individuals, what their motives were. It could be a business transaction. It could be a donation to a charitable organization that actually is engaged in the activity that is counter to global peace. And so there is this dynamic where, and it may be something about a lot of our clients have their own planes, their own yachts, and with that just comes a lot of, I don't know how to characterize this, as good people as well as hangers-on. And those hangers-on tend to generate a lot of trouble, we've noticed in the past. Aside from business activities, something else that could create issues is foreign travel. If you spend a lot of time, taking family vacations to certain countries that the U.S. has concerns about, that alone in and of itself could be a red flag to the government, something that could be explained if you have family over there that you're visiting or attending a funeral. These are all plausible and reasonable explanations, as opposed to going somewhere and spending your time at a terrorist training camp. But people do travel to places that I would view to be, and my colleagues would view to be, precarious, dangerous, but they go for good reasons, or maybe they're going for charitable reasons. And these are all issues that you can typically work through the government. Again, transparent, making sure that client's comfortable with the level of information that's being provided, and making sure that the government is comfortable that the client is being credible and honest and forthcoming. Another thing we've seen is family members. So the client may be engaging in activity and have a pure record in all respects, has done nothing wrong whatsoever, but there may be an uncle, a cousin, a spouse, a brother. There's always some wayward uncle in these stories, it seems, who's doing things that they should not be doing, much to the chagrin of the client when the client learns that this is happening. And in those instances, the government might cancel the visa of what I'll just characterize as innocent family members, because the government's not entirely sure what is going on, and also not entirely sure that these other individuals, these other family members, are in fact innocent. And so part of what we do is help distinguish between what the client's views are, positions are, activities are, versus what a family member's may be. And then the other point I just wanted to raise, and this list, by the way, is by no means exclusive. There are other types of things that we've seen over the past, but these are just some common themes. And I would just characterize the fourth one is foreign political contacts and activities, and that can cut both ways. So, for example, if the client is supporting or viewed to be supporting or providing material support to a regime that all day, every day engages in human rights abuses, what we would call bad actors, the client could have trouble getting a visa. And we kind of work through those issues. The flip side, of course, is if the client happens to be from a particular country that maybe is engaging in nefarious activities, but the client is actually trying to assist with regime change or is an opposition leader, the host country, we've seen this before, will put out alerts, what are called via Interpol, what are called red notices, and start making allegations that the client, who everyone on this call would view to be a do-gooder, is actually engaging in unlawful activity. And those will be specious, untrue allegations that we then have to work through. And then another thing, this is sort of where maybe the family members and business relation dovetail. We've also seen instances where, believe it or not, if a client is engaging in, it could be a business activity, a business deal that has gone wrong, or it could be getting into one of these internecine family disputes with a family member. The other party will go to either the U.S. government or some other government and accuse the client falsely of any number of different horrible things, sort of running the gamut from narco trafficking, human trafficking, providing material support for terrorist activities, and the allegations are completely untrue. And so part of this is, working with the government, trying to unpack the allegations. Again, all the while working with the client, making sure that the client, the most important thing from our perspective is to make sure that the client is being transparent and is comfortable. As I said at the outset, a visa is a privilege, not right. Plenty of instances where the client says, you know what, I'm pretty comfortable with the status quo. I can visit any number of different countries. And I think I'm just going to hold off on seeking to pursue my U.S. visa at this time. But more often than not, the vast majority of the people that we encounter do believe that they've been aggrieved in some way, and our role is to help facilitate the flow of information to the government while representing the client's interests. So those are kind of my summary. I do think that these issues transcend the current administration, the Trump administration, before that, the Obama administration. These are sort of evergreen issues that we just kind of see all day, every day. And again, we've had some success here at the firm in helping people get those issues resolved. So thank you so much for joining. I can't wait till the time comes we're actually going to be able to do this in person. And it's going to be great when we do. So thank you for your time. And also, I'm going to now turn it over to my colleague, Lauren, who's going to talk about tax consequences associated with immigration issues. So thank you.
Thank you, Jason. So as Jason said, we're now going to go into the portion of the presentation that complements what both Leon and Jason were talking about with respect to visas, and focusing on the tax consequences in the United States of those visas, and some hot issues that are tax related. Not maybe as exciting as the ones that Leon and Jason touched on, but they do wrap in pretty nicely with the first two portions of this presentation. So starting out, when we're talking about visas with respect to U.S. federal tax, first you need to determine which type of visa, or what type of visa do you have, either an immigrant visa or a non-immigrant visa. Going into the immigrant visa types, there are two types. There's the lawful permanent resident, or the green card, and there is the employment-based, or EB type of visas that I'm sure you've heard of. Going into the types of non-immigrant visas, this is not an exclusive list, but this is some of the main types of visas that we see in our practice. We see a lot of student visas. We see a lot of, sometimes we work with diplomats. We see a lot of, specialty occupations, teachers, and all types of visas. And also, as Leon had mentioned in his presentation, we do see that TPS type of visa as well, especially right now with respect to Venezuela. And I'll kind of pose a few questions towards the end of my portion of the presentation as to the tax consequences of those visas. But it's important to kind of start out and classify the type of visa that you're dealing with, because it's going to impact both the U.S. federal income tax consequences, the transfer tax consequences, which include, estate and gift tax. And in addition, it might impact the type of filings for tax purposes or FATCA purposes that the person will have to file in the United States based on the type of visa that they have. So of course, just to kind of give a bit of an overview of what we're really talking about, we're not referring to anyone who's a US citizen. A person who's a US citizen is already subject to worldwide tax on their worldwide income. So we're not referring to anyone who's a US citizen. We're talking about persons who are U.S. Resident aliens under different types of tests, which turns on the type of visas that they have. So when we're dealing with a client and we sit down with the client and or the client's advisors and we start to determine, what type of, where we're going to classify them and how we're going to help them with their tax planning, here are some of the main questions that we'll ask as we sit with them initially. We'll want to know, and you'll see as I go through my portion of the presentation, why all these questions are important. We'll want to know how much time they've spent in the United States this year and the last 2 years. As I'll talk about, there's COVID legislation that may change that slightly for 2020. Do you come from a treaty country? The United States does have treaties, income tax treaties with a number of other countries. So it's important to know whether they are from a treaty country or not, because that can vastly impact the tax consequences. Do they have any current or previous US connections, visas, family members? I think we asked that question. I never really think about it as Jason was pointing out, you might have family, like the wayward uncle who's doing all this crazy stuff. So now I'm probably gonna think about that family member question a little bit more in a different context than I usually do. You're going to want to know what type of connections do they have outside of the United States? Do they have a home outside of the United States, businesses, investments? Is that something that they want to keep, or is that something that they kind of want to wind up and move stuff more to the United States? Family members, or they have immediate or extended family members outside of the United States? Where do they really, what do they think of as their home, their nationality? All of these things, and you'll notice they're in the parentheses on the slide, all of these kind of go to various tests that we will look at to help determine what the US tax consequences are of their time spent in and outside of the United States. And the last point on the slide is, do you plan to leave the United States in the future? This question specifically goes to US transfer taxes, which are estate and gift taxes, as opposed to a lot of the beginning questions do touch more on the income tax side of things. Okay, so when we talk about US income tax residency as opposed to transfer tax residency, estate and gift tax residency, looking at income tax, it's more of an objective test. So there's two things you're going to look at. One, do they have a green card? If so, they are a US resident. If they're in the United States, they have the green card. That test is very straightforward for the most part, leaving aside all the many nuances we could get into. And then the second objective test is, are they meeting a substantial presence test, which we'll go into briefly, I think on the next slide, which is a weighted 3-year day count average. The impact of these two tests is, if they are US resident, they will generally be treated to worldwide income taxation. They'll be subject to controlled foreign corporation and PFIC anti-deferral regime rules, which are very important. And then also, as I mentioned earlier, they may be subject to international information reporting as well, which can really, sometimes people don't realize that is going to impact them as much as the income tax. And a lot of the time we are going back and cleaning up when people have not properly reported certain foreign entities, trusts, bank accounts. A lot of what I do personally within the private wealth group is dealing with foreign trusts, either with a foreign grantor and US beneficiaries, and there can be a large host of rules and reporting requirements and income tax penalties that can apply if you do not report and structure trusts and of course other entities properly. So going into the substantial presence test, the way that is calculated or determined is you have to look first to the current calendar year. Is the person here in the United States for at least 31 days during the calendar year? And then also, are they present in the United States for 183 days or more, taking into account all the days in the current year, 1/3 of the days in the first preceding year, and 1/6 of the days in the second preceding year. So basically, if you're treated as a US resident under the substantial presence test, then you have to keep your presence in the United States to 121 days or less is our general rule. Obviously, we tell clients to try not to play that too close to the 121 days, because sometimes things do happen and you don't want them to to fall into any traps with that. So looking at the substantial presence test, this is the look back rule. You can also fall under the substantial presence test classification or test if you spend 183 days in the United States. There are exceptions to the substantial presence test. One of them is the closer connection exception. So if you are present in the United States for 183 days during the current year, but you maintain, or less than 183 days in the current year, you maintain a tax home in a foreign country, you maintain a closer connection to that tax home, and you haven't applied for or taken any steps to apply for a green card, then you should fall under this exception to that substantial presence test. So obviously, when we're working with clients, it's very important that we get their day count and that we get all of their records of when they went in and out of the United States. A lot of the times we'll call up, Leon or Jason or someone in our firm to try to make sure that we're coordinating with, the immigration laws properly, and that we're tracking everything, the right way. But so this is a very important exception that we'll use for a lot of our clients. Another exception is for exempt individuals. This one comes up quite a bit in our practice. Like I said earlier, we do have a lot of clients that do come in under these non-immigrant visas, for example, for students or teachers or trainees. And so you have to look at, if they have this type of visa, then you can generally exclude the days that they are in the United States with these visas. You do have to file certain forms for these exceptions. So for the closer connection, as I mentioned before, it's Form 8840. And then if you're falling under these exempt individual type of exceptions, then the form is Form 8843. One thing to be very to be aware of is if you do fall under this exempt individual exemption from U.S. income tax, there is an exception if you spend 183 days or more in the United States. You may be subject to capital gains tax on U.S. income. So that's something to be wary of, because non-U.S. non-resident aliens generally are not subject to capital gains in the United States, but this is an exception, and this can really be a trap for the unwary. So that's something to be aware of. And these visas generally are only for a certain amount of time, and then once the visa is no longer available for that person, they either have to move on to a different type of visa or get their green card, etc. And then we'll of course work with our esteemed immigration team on those types of issues. So just note that these will only last generally for a certain amount of time. Another exception to the substantial presence test is the medical condition exception. This is, we have used this a number of times for clients who have a medical condition that does not allow them to leave the United States. This cannot be a pre-existing condition that they come into the US with. This has to be something that arises while they are present in the United States. And it cannot, so for example, if they're leaving in a month and they end up leaving anyway, they can't use this exception even if they did have a medical condition arise. There is a form that has to be filed for the medical exception as well, the Form 8843, and there is, in addition, and very relevant to to the tax filings that are being done now for 2020, there was a COVID emergency travel disruption exception as well that allowed that person, if they were disrupted due to COVID, if their flight was canceled or something else happened that was COVID related, and there's a whole host of rules and definitions, then they can exclude 60 consecutive calendar days between the period of February 1 and April 1 of 2020. So that's something that is important to note as well. I think the last exception that we have on here to the substantial presence test is the treaty tiebreaker exception. As I mentioned in the beginning of the presentation, we can use a U.S. Income tax treaty with a foreign jurisdiction to accept the person from being treated as a resident alien for U.S. income tax purposes. So you always want to check to see if that person is from a treaty country. And then I won't go through, but there's a tiebreaker test that goes through these different permanent home, federal vital interest, habitual abode, nationality, that all tie back to the, the questions that we asked in the beginning of the program, or in the beginning of my portion of the program. In addition, so we all of those issues kind of touched on, income tax issues. The estate and gift tax residency is really a different ballgame because it is a subjective test. So really it just ties to, you have to ask them, where do they intend to reside indefinitely? If they intend to reside indefinitely in the United States, and there's evidence to show that, then they are generally going to be treated as a domiciliary for U.S. transfer tax purposes. What is the impact of this? That person will then be subject to estate tax on worldwide assets. As most of you, if not all of you know, the current exemption for gift and estate tax is 11.7 million. Under the current administration, that will be going down. We don't know when, and we don't know how much, and we don't know when that will become effective, whether it will become effective when on the date the exemption is decreased, or if it will be retroactive to some date, for example, January 1, 2021. So that is something to definitely look out for, and to be talking to clients now that, may want to move assets into an irrevocable trust or do some other plan. That exemption does go down, bearing in mind any concerns that it may be retroactive, and planning for that as well. So if the person is treated as a domiciliary for U.S. Estate and gift tax purposes, there's a host of consequences, including, they may be able to transfer to spouses now with a marital deduction. But that being said, now all of their assets in the world are going to be subject to estate tax, less the exclusion. So that's a very important question to ask, and there's a lot of planning that we do before that person does become either a resident for income tax purposes or a domiciliary for transfer tax purposes. On the next slide, we do have just a few planning techniques that we will utilize for both of these areas of tax. For example, for income tax exposure, we may step up cost basis and appreciated assets, accelerate gain on appreciated assets this is all before they're becoming a U.S. Resident for income tax purposes, defer losses, dispose of PFICs, which I had mentioned previously, planning for future foreign tax credits, and converting and or checking the box on foreign eligible entities. These are very standard pre-immigration planning techniques that we will use for our clients. And then also, as I mentioned before, we will minimize transfer tax exposure by transferring assets to trusts that are U.S. estate tax exempt. In my time, I've been a lawyer now for 8 years. Over that time period, it's become much more common to set these trusts up in the United States as opposed to in any other jurisdiction. And so we are setting up a lot of trusts in the United States that are either treated as foreign or U.S. for our clients, depending on their family structure, whether there's U.S. beneficiaries, non-U.S. beneficiaries. So that can be a very interesting area of practice, and we do a lot of planning in that arena. Another thing that you can do if you're going to become a domiciliary is make advance gifts out of your name, either individually to persons or in trust or otherwise, so you get them out of your estate. I think we're coming up to the end of my portion of the presentation, so we wanted to open it up for questions on any of our portions of the presentation, if there are any.
Lauren, one of our colleagues submitted a question reminding me to talk about visa fraud, which is an issue that you, Lauren, Leon, and I encounter, and we encounter it because we always tell the client, how important it is, whether it's the tax, context or immigration context, about what we were talking about earlier, just the importance to be honest, transparent. And we always tell the clients, I always tell the clients, I'm not a doctor, but I believe in the Hippocratic Oath, which is to do no harm. So we never want to make things even worse for the client. But always reiterating the importance of being correct, accurate, truthful when you're submitting information to the government, including when you're seeking a visa. And we've had clients where they'll come to us and they'll say, well, I'm not sure what the problem is, why I'm having trouble getting my visa renewed. And you spend quality time with them, and then it comes out, well, actually, I failed to disclose the following 3 things. And then we talk about how best to clean that up. And then there's some, there may be some instances where if they made material misrepresentations, there's you're limited as to what you can do to address that. But it's also good, I think, to seek a lawyer, whether it's us or others, to seek a legal counsel, because you also don't want to encounter criminal liability in connection with pursuing the visa. So we always remind the clients that in certain instances these people have great lives, and again, as I was saying earlier, if there are issues and they're just not comfortable pursuing the visa here in the United States, we talk through those issues. But again, almost in every instance, these people have a plausible explanation, and the government can then assess as to whether or not this person deserves a visa. But I did want to highlight for folks that there are significant, and Leon and Lauren can speak to this every bit as well, if not better than I can, but there are significant ramifications, consequences of making misrepresentations in visa applications, including renewals, including if you're trying to explain to the government why they have the wrong person. Anytime you provide information to the government, again, whether it's immigration, tax, that information always has to be to the best of the person submitting it, true and accurate. And so I thought I would just highlight that, really, because my thoughtful friend reminded me, and I'm not going to go into the details of it, but he and I together had another typically wild case that involved facts where the accuracy of the information that the client submitted before he ever came into our lives became questioned. And so we did our best to clean that up.
I have a question for our panelists. I'll start with Lauren, which is, Lauren, we talk a lot today about people wanting to come into the United States and their tax issues, but we're also seeing a large number of people who are U.S. citizens wanting to renounce their citizenship and leave the United States. Are you seeing that, and what are some of those considerations?
Yeah, Leon, we're actually working on a number of clients right now who are leaving or who already have left. I think it's interesting for the ones who are leaving, looking at their primary objectives of why they're leaving, usually, tax considerations, of course. They're having businesses that likely right now are worth maybe not as much as they will be in the future. And so they're trying to get out of the United States, before they do that. We also have clients who have already left and are now dealing with situations where, they want to make gifts to spouses who may in the future no longer be a spouse, or, they have children that they want to make gifts to. And there's issues once you're a covered expatriate, which there's certain tests. Primarily you have a lot of money when you leave, and then you cannot make gifts to your U.S. beneficiaries without them having to pay tax. So there's a lot of different issues that we'll look at both before and after they're leaving. But at least the main ones that I'm working on, it seems that they have business operations that are likely going to be much more valuable in the future, and so they're making decisions on that basis.
Yeah, that Lauren and Leon, that's a great question, because it reminds me that we've all had, not often, but we have seen it because we've worked on them together. But cases where someone will renounce, give up U.S. citizenship, and then fill in the blank. A week later, a month later, a year later, decide, what? Actually, I regret that. I wish I had not done that. Because it can be very, very difficult to get that back. And so what I would tell, I see those people you know, when they're coming back and saying, you know what, I regret having done that. If I had been able to counsel them on the front end, I would always, you know, remind them that it's a decision that should be taken very seriously and be given a lot of thought, a lot of weight, and be done with the understanding that once you give up your citizenship, you may never again get it back, which for a number of people, for all the reasons that Lauren has touched upon and that Leon is well aware of, they may decide that, yeah, they've made that decision and they're comfortable with it. But again, we have seen people that do decide to renounce for U.S. citizenship and only go on to regret having done so.
We have a very interesting question on the thing. I know on the chat board, Lauren. It seems like a tax question, so give it a shot here. Which says the client has dual citizenship and travels abroad on a non-U.S. passport, which people do all the time, and they die out of the country. Will the foreign citizenship on a foreign death certificate call their U.S. exemption status into question? Have you seen that, or tell us about that?
So if we're talking about dual citizenship, you know, U.S. citizenship and citizenship in another country, you're a U.S. citizen. So, you know, the U.S. exemption issue is not really going to be called into question. Where it has been called into question is if you are not a U.S. citizen, but you are potentially a U.S. domiciliary, which is that subjective test that we talked about. So it's subjective. You know, there's a question as to whether the person is a domiciliary, and if they leave the United States and they die, then there may be a question. There's actually cases in the past where someone tried to use their exemption, you know, as a benefit to try to reduce the amount of assets that were subject to U.S. estate tax, and there was a case where they were not able to use that exemption in that scenario. So to answer your question, no, if you're a citizen in the United States, your exemption status won't be called into question, but if you're a domiciliary, then it could be. Yeah.
Okay, do we have any other questions from anybody? It does not look like it. Okay, so without questions, I think we've concluded our presentation. You can reach out to, we don't have our slides here, but you can just go on the Holland Knight website and look for Jason Klitenic, Lauren Klein, myself, Leon Fresco, and they have a little link that you can email us with any questions you have on anything you've seen in this presentation, and we'd certainly be happy to discuss those with you. And we thank you for your participation today.
Thank you.